This is the Know Your Law series by Barefoot Law, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Welcome to this webinar. Thank you, Rhoda, thank you, Rebecca and Sandra, for being part of this session. We're just going to discuss and understand how succession works here in Uganda. I'm going to hand over the microphone to Sandra and ask her to share more on section 15 of the Act. Yes.
Okay, so thank you so much, Daphne and Rebecca. By the way, for your information, Rebecca was the first person to really train me on the succession law and all that. So I'm really happy that she's here and she's doing it. So about the section 15, it says that the domicile of a wife during the marriage follows the domicile of a husband. So for me, by just saying this, the domicile of a wife during marriage follows the domicile of a husband is already even discriminatory. By just saying follows, you get following, meaning that really the woman has no right, it's just to follow without her having her own decision to decide. So just briefly, domicile means the legal resident for this case. So based on the law, of course, both men and women are entitled to the equal rights in all matters. And this means that any form of discrimination that is based on their gender should be outlawed. So that means that already by having this saying that when a woman gets married to a man, it's automatically that she takes up the domicile of her husband, which is discriminatory in nature, because a woman should have a decision and also a chance to decide whether she would like to take up the domicile of her husband or not. And of course, in this case, based on the succession law, it's discriminatory in the fact that maybe in case God forbid the husband dies, it becomes very hard in terms of the succession aspect, and also the aspect of getting maybe if you want to get a divorce from your what, or if you want to get a divorce with your husband. So this is where the case also comes in. But also it also means that it's if a woman can automatically get automatically acquires the domicile of her husband, that means that women really do not have rights over properties they acquire during marriage without consulting their husband. And this means that even though we have about 27% of women who have acquired property, also this depends on the status of their marriage. In case maybe the woman divorced the husband, she's at a higher risk of losing all the properties maybe she acquired during the marriage. But I'm happy that this is going to be like a repeal in the new law, and also maybe just highlighting it also when maybe a man acquires a new domicile by taking up his fixed occupation, maybe in another country, is not that of a domicile of his origin, except that if that man is not to be considered as having taken up his fixed occupation in Uganda merely by the reason of residing there in the exercise of any profession or any job. So the provision that a wife takes up the domicile of her husband at marriage or vice versa and not vice versa is very discriminatory. And of course, it falls short of the constitutional standard of the equality between the spouses at marriage and also during marriage and at its dissolution. So the possibility of the law making provision of of the parties at marriage, or to have equal right to determine their domicile, or to retain their domicile of origin, should also be considered. And of course, we need to really reform the Act to bring in conformity with the Constitution and the issues that needs to be addressed, which include the gender insensitivity of some of the sections, like Section 15. So this section is really very, it evaluates women's rights, and also in a way it also affects the children in future, as they're going to own properties, maybe which are owned by their mothers. So that is what I wanted to talk about. So it is very important that the law recognizes that women also do own property, and require the legislative regime on inheritance to consider the passing of their property in instances of maybe when one person dies. So yeah, so I'm happy that with the new repeal of the law, it will provide women the right to depose property they individually acquire during their marriage without consulting their husband, which is very important. And I'm happy that we are having this conversation, and we would like to really hear more from the people who are attending to hear their views about the succession law. Thank you so much, Daphne.
Thank you, Sandra. This is to Rebecca to kindly just brief us on the president's response. There was also a question in the chat similar to that, on whether the law has been operationalized. Yeah, so how far is it now? And yeah, what was the president's response? Yes.
So I was saying that the law-making process is such that after the third reading and the law has been passed by Parliament, it then moves on to the next stage, which is presidential assent before it is recognized as law. For some bills, particularly, it requires that there's like a statutory instrument that let's say, operationalizes the bill. But for this particular bill, we made sure that there was none. And once the president assents to the bill, then it becomes law. But now the bill was then sent to the president for assent. And the president has the option to, one, either assent, completely reject the bill, or three, to send it back for reconsideration on particular clauses. And when he does send it back, the reconsideration is restricted to just those particular clauses that he mentioned. So it's not opened up for debate completely. It's just that those particular clauses that he mentioned should be reconsidered and reviewed. So in a letter dated 22nd July 2021, she basically wrote back to the Speaker of Parliament and raised two concerns on two clauses. That's clause 14C, the one that we mentioned, gives 80% of a property to a surviving spouse, and then 20% to the dependent relative where there is no child and customary heir. So he said his reasoning for dissent on that particular clause is that there's no justifiable reason to increase from 50%, what is in the law currently, to 80%, and only give the dependent relatives 20%. And he said this would also create disharmony between the surviving spouse and the surviving and the deceased relatives. So he even proposed that the widow is given 50%, and then the dependent relative 49%, and the customary heir retains 1%. This is also because usually the dependent relative still surviving are maybe a parent or like a niece, a nephew. So it's equitable that they also get something substantial because they were close to the deceased. So in a response letter that's now being prepared and being submitted to the Committee on Legal and Parliamentary Affairs, we conceded to the President's proposals, but based on different arguments, really. One of the arguments that we had was that it's very common now that children that were not known of a deceased may emerge after the deceased's passing. And then the children of the deceased can benefit from the 49% of the estate that was then distributed to the dependent relatives, like he proposes, instead of getting it from the 50% of the serving spouse. And then we also thought it's not such a bad proposal, because already there's been reservation of the principal residential holding and or home or other residential properties for the surviving spouse. So already they've been catered for in an equitable manner. So we conceded on that fact. Then he also had an issue with clause 18(1)(b) that seeks to amend section 30 of the act that basically deals with separation. The law is to the effect now that if you have been separated for a period of 6 months consistently before the death of your spouse, then you should not benefit from the estate of your deceased spouse unless you fall within certain parameters. Either you are in school and others that they mention. So here we say, what it reads now is, a surviving spouse of an intestate shall not take any interest in the estate of an intestate if at the death of an intestate, A, the surviving spouse was separated from the intestate as a member of the same household, B, the marriage between the surviving spouse and the intestate was suspended either by an agreement or judicial order. So that is the one that he had a problem with in particular. And the reason he had a problem with this, he stated that the phrase suspended either by agreement, when it says suspended either by agreement or by judicial order, is ambiguous and likely to cause confusion in the administration of estates. And then regarding separation by a judicial order, he said when a marriage is suspended by judicial order, court has to make provision for sharing of the property between the parties. And for my legal lens, that is not true. Sharing of property only happens when there is a divorce and a decree NISA is now being issued. So when it's still a separation, there is no sharing of property happening between the parties. So we think that we dissented with his arguments. So he said there's therefore no need for Parliament to provide for sharing of property when a judicial order has been issued. So also in our response paper, we agreed with the President's proposal to eliminate this particular provision. However, it was also based on different arguments. We said, one, separated couples will still be managed by judicial order. There's no need to reinvent the wheel if it's persistent. However, we noted that separation orders, judicial separation orders have the effect of only upon further consultations with those in the judiciary and those in practice, only have the effect of suspending conjugal rights and not any other rights within a marriage. So you still have other persisting rights, but they only suspend conjugal rights. So it would therefore be unfair for you to disinherit a separated surviving spouse that just had a judicial order of separation, and yet only conjugal rights had been suspended. It clearly indicates that there is still a subsisting marriage, and there was even a possibility of maybe reconciliation happening later on. So we should not disinherit them. So we concurred on that particular point as well. So we hope that now that we have these responses have been submitted to Parliament, Parliament will then, the committee has the opportunity to review those particular responses from different stakeholders, the movers of the bill, WOPA, and then send it back to the president with those with that input. And hopefully now that majority of people have considered, regardless of the fact that the arguments we use different routes to get to Rome, he will assent to the bill, because he only had issues with 2 clauses, which for us was okay. They were not fatal, and the lawmaking process is really about negotiation and trying to get a middle ground. So we hope that after assent, once it's assented to, then it has full force of law, and it's at that point that we can consider it the new succession law of Uganda. Thank you, Daphne.
Thank you, Rebecca, for that, for taking us through that process. I would like to ask, why is it so difficult to get government to act on legislation that relates to gender discrimination if there is an increasing number of female MPs and ministers?
I think for me, I can only speculate, because honestly, I cannot speak on their behalf, but I would assume that it's not, it's a matter of priority. So if you don't push and shove and really make it, don't make a case for urgency, there's really reluctance on the part of government, particularly the legislature, to have these bills passed. They don't see the urgency for which you are pushing these laws. So sometimes it's important for you to make arguments based on fact. A number of researches, for example, have been done here that establish that, one, productivity on land increases significantly when women have control and ownership rights over land. That speaks to issues of the economy, the GDP of the economy getting better. Some of those arguments are more persuasive to these people than just putting it out there. Discrimination and gender-based arguments, they really tend to be reluctant. And also as opposed to more politically driven laws. So I don't know why that is the case. Probably also because these tend to change the status quo in how things are done within our society, and people usually, their usual reaction is to desist and resist change. So I guess that is why. But the best person to respond to this probably would be a member of parliament to speak on their behalf.
True. All right, one more is from Ainomukisha Agri. Some sections of the act have been declared null and void. So how has this impacted on the family law and the matters at hand? So would you be able to just highlight some that were null and void and had, I think, repercussions? Yeah, that's, I think, what we want to know.
So I think the various presenters have really tried to explain and elaborate the various repercussions that this has. And the amendments were addressing particular sections that had been declared null and void. Sandra talked about the sections to do with domicile, illegitimacy of children. I think Rhoda spoke about some. We've also spoken about the ones to do with distribution of property. So one, really amendment of these sections was prudent because, one, they were largely discriminatory on the basis of sex. Where they were not, they were unconstitutional because they were in contravention with the Constitution, even beyond clauses of discrimination and other international and regional instruments that we have ratified as a country, but also they were out of date and no longer in touch with our reality. So it was necessary to get rid of them and have something that's more contemporary and speaks to our reality as a country. So I think, one, definitely they'll improve things, how things are being done, especially one that I can think of head is administration of estates of an intestate, and also where there's been a will, grant of probate, because largely what is happening right now is once letters of administration are granted, then the administrator assumes the position of the deceased. They never ever distribute the estate. They never file an inventory with the Administrator General's office and never distribute. So they assume the position of a deceased, manage their funds of the estate and keep receiving, say, if there are periodic incomes, receiving on behalf of the beneficiaries and never remitting to these particular beneficiaries. If it's land, they are selling land and disposing of properties and assets of the estate and benefiting in place of the beneficiaries. So now that power has been checked, because if after 3 years you have not sufficiently carried out your duty as an administrator or executor, then you're brought to book when they bring you back to court, or automatically these letters will expire. Then the family has an opportunity to come to court and say, look, this person that we appointed as administrator or executor has been largely has abused their powers. We've never been able to get what is rightfully ours, and they have sold or disposed most of their estate. So there are repercussions for such a thing. So it will ensure there is more efficient administration of estates, properties distributed in time, and such things are dealt away with. But also it's largely protecting, say, the principal residential or the homes of the surviving spouse. Thank you. Because now they have more than just an occupational right, but are also, they are owners in the real sense. They have a reversionary interest in this property. So those are some of the things that I could think of. But I think generally the amendment is for the better of things, largely or entirely. Thank you.
All right. Thank you for that. I would also like to give a big shout out to Digital Human Rights Lab for enabling us to have this discussion. Thank you guys for your time. Thank you, Rebecca, Rhoda, and Sandra, for sharing your insights. I think this has really been insightful on many fronts. And we hope to have more of these. Yes, so have a great afternoon, stay safe, and yeah, bye.